So we have a judge who's highly conflicted. You know what the confliction is. Nobody wants to write about it, and I'm not allowed to talk about it. If I do, he said, I get put in jail. So we'll play that game a little bit longer. We won't talk about it, but you're allowed to talk about it. I hope you do, because there's never been anybody so conflicted as this. As far as the trial itself, it was very unfair. We weren't allowed to use our election expert under any circumstances. You saw what happened to some of the witnesses that were on our side. They were literally crucified by this man who looks like an angel, but he's really a devil.
We are watching former President Donald Trump in his first lengthy remarks after being found guilty on 34 counts of document-related charges. This is taking place at Trump Tower. He began his remarks with what could actually be regarded as political remarks about various things that are part of the campaign, from immigration to car imports, but then has turned, of course, into the guilty verdict and his interpretation of the case, in some cases factually incorrect, which we'll get into in just a moment. We were told this was going to be a news conference. We are going to watch and wait and see if he takes questions in the meantime, and we'll continue, of course, to monitor his remarks. In the meantime, let me bring back Laura Jarrett, NBC News senior legal correspondent, Danny Cevallos, also here, an NBC News legal analyst. A lot to parse through here, a lot of claims here. Let's pick one.
Let's start with the gag order.
Start with the gag order. He did make comments, obviously referencing Michael Cohen. I think most people would agree that's who he was discussing.
Yeah.
Michael Cohen still covered, and the former president certainly covered by this.
So the purpose of the gag order, remember, is to protect the witnesses from being attacked so that it doesn't influence their testimony. The purpose of the gag order is to be there in place for the duration of the trial. When he was fined before for his violations of the gag order, it was for making references about Michael Cohen, similar to the types of things that we heard today. I'm interested to see whether, now that the trial has been completed, his attorneys actually asked for clarification to say, hey, Judge, is he still under the terms of this gag order until sentencing? Because there's an argument, I think, from the defense side to say, now the trial is over, he should be allowed to say whatever he wants. I could see the prosecutors pushing back on that in the event if for any reason they think there's still some witness intimidation. So I think that's an issue. We're going to reach out to the defense on their position. But he seems to be operating under the assumption that he is still under the gag order. He referred to himself as under it.
And we should note he also has repeated several times that he still wanted to testify, talking about the jeopardy that most lawyers will advise you that if you put yourself out there, but again, maintaining that he wanted all along to testify. Another point I think we have to deal with is he repeated the claim that this is all the result of President Biden or the White House, Democratic operatives who've made this happen. This was a state prosecution.
A state case indicted by a state grand jury, and now a grand jury, now a jury of 12 in New York finding him guilty. This was not a decision reached by a judge. This is not a decision reached by prosecutors, certainly. This was a decision reached by a jury with no connection, no discernible connection to the White House or the Justice Department. It's a claim that he's tried to surmount for political reasons throughout this trial. And
Danny, let me ask you, he also went into a very long defense of the criticism of the trial and what they wanted and what they didn't get. He said the government got everything it wanted in terms of requests to the judge. Is that a fair characterization?
No, not exactly. I mean, the defense won some points throughout the trial, but one of his main complaints, for example, is that they weren't able to call an election law expert. But even his own attorneys had to know that was going to be a challenge to get that expert on the stand. Because while you can call experts on issues that are beyond the average knowledge of a juror, like blood spatter experts, firearms experts, fingerprints, things like that, something like an issue of law, and Justice Merchan said as much, is an issue that the judge will instruct the jury on. You can't call generally an expert to tell jurors what the law is. That is the province of the judge. And that's why the judge did not preclude that expert.
Right.
The judge instead limited the scope of testimony of that expert. And Donald Trump just acknowledged as much, saying that there were areas that he would have been able to testify about. They made a strategic decision and decided not to call the expert.
But is all this par for the course in a typical criminal trial?
Absolutely. You don't get to call experts to discern and to try to decipher the law. That's for the judge to do.
Right. You can't call an expert to say and qualify the expert as he may in fact be an expert and qualified as an expert, but you can't turn to him and then say, tell the jury what the law is and tell the jury that what the defendant did was in fact lawful. That is literally what the purpose of the jury instructions are. That is why they are instructed. And that's exactly what the judge said. Maybe not verbatim, but essentially, I will instruct the jury on the law. Therefore, these are the limited areas that your expert can go into.
He also talked about this case being only a misdemeanor. In fact, it was boosted to a felony, correct?
Boosted to a felony in this case. And we should be clear that the way that they sort of attach their wagon in this case to a felony is novel. We have not seen that before. We have seen plenty of falsification of business records cases in New York and other places. But the way that they went about it by sort of latching it to a federal violation of campaign laws, that is novel. That is untested. And it hasn't been done before. And it's one of the reasons that he's right that many prosecutors didn't want to bring this case, including prosecutors in this very office in Manhattan. But they ultimately decided that they thought that they could bring it. They thought that it was valid. They thought that it was legal. And he's also right. The prosecutors in the Southern District of New York did not bring this case, but he's wrong about why. The reason they didn't bring it is because he was president at the time. And so they couldn't prosecute a sitting president.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.